Welcome to the Privacy and Technology Law Section CLE program on restrictive covenants. We're happy today to welcome Mari Meyer, who's a former section chair of the Privacy and Technology Law Section, as our speaker. Mari is the founder of the Meyer Law Firm. She's a graduate of Boston University College of Law and Wellesley College with a BA cum laude. She has extensive experience litigating business and employment disputes, including matters involving restrictive covenants and employment agreements, employment separations, and business divorces. She also negotiates and drafts employment agreements, separation agreements, and related types of documents, and advises clients regarding a variety of employment and business matters. Her clients include small and medium-sized businesses as well as individuals. As I mentioned, she's a former section chair, and she's a current member of the Atlanta Bar Association Litigation Section Executive Committee. So welcome, Mari. What we'd like to do is ask you to put your questions in the Q&A function on Zoom, and we will save those for the end. And so take it away, Mari.
Got ready to speak and realized that it looked like I was muted. So thank you, Elizabeth. I am delighted to be here. It's a fascinating topic to me to talk about restrictive covenants, and so I hope that that it will be for the rest of you as well. Those who have followed restrictive covenant law in Georgia may already be aware of a lot of what I'm going to say today, which is basically that Georgia has had an incredibly complex and tortured history when it comes to restrictive covenants over the last probably 30 years and definitely over the last 12 years. So the background is that Georgia has a constitutional provision that that says that contracts that are deemed in restraint of trade are unconstitutional and unenforceable in Georgia. And so up until May of 2011, essentially Georgia's restrictive covenants law was that restrictive covenants of any type were considered partial or complete restraints of trade, and therefore would be subjected to strict scrutiny and very often not enforced. There was a change in the law in May of 2011 that I'll get into in a couple of minutes. But first of all, I'm going to talk about what we're talking about when we talk about a restrictive covenant. And that is that it's an agreement between the employer and the employee to protect property, confidential information, relationships, goodwill, and the like. And so it is intended to protect an employer from conduct that an employee might engage in that could be harmful to the employer and caused financial damage or other kinds of damage to the employer. Typical covenants that we talk about in Georgia are a non-compete, which is an agreement not to compete with the employer for a period of time in a particular territory, a covenant not to solicit certain customers, a covenant not to solicit or poach coworkers, and a non-disclosure agreement. Prior to May 2011, there was no statute that was in effect in Georgia. And so effectively we were dealing with case law interpreting these kinds of covenants, and they were subjected to strict scrutiny. What's interesting is that even though the law changed now almost 11 years ago, there are probably more cases from 2011 forward that litigate over these old agreements than litigate over agreements that were signed after the law changed in 2011. And so one practice tip I would suggest is that for those of you who who negotiate or draft these kinds of agreements for companies, or who just have clients who have these kinds of agreements signed by their employees, suggest that your clients update their agreements and get them signed sometime soon so that they will be governed by the new law. Now, the new law, which is now 11 years old, but still considered a new law, applies to anything that was signed after May 11, 2011. And without going into a lot of detail, essentially there was an effort to change the law in 2010, which entailed both an adoption of a new statute, Restrictive Covenants Act, and a constitutional amendment authorizing the change in the law. The constitutional amendment was adopted following the election in November of 2010. The law was adopted before the constitutional amendment was adopted. And so the law had to be repassed with some changes in May of 2011 so that it could then be based on the constitutional amendment that had been adopted in November and went into effect in January 1, 2011. So May 11, 2011, we get a new law, and it only applies to restrictive covenants that were signed on or after that day. Now, what's covered by the law? Well, first of all, there's a very broad definition of employee. It's not just a W-2 employee. Under this new law, an employee can be an actual W-2 employee, an independent contractor, a franchisee, a distributor, a lessee, a licensee, a party to a partnership agreement, a sales agent, a broker. Basically, almost anybody can fall within this concept of an employee under the 2011 Restrictive Covenants Act. The definition of employer is equally broad. The employer is who can enforce the obligations of the employee under the agreement. And the employer can be a corporation, a partnership, a proprietorship. It can be for-profit or not-for-profit. Those all probably are fairly intuitive concepts. But additionally, an employer can be a successor in interest to the entity that was actually protected under the agreement. And an employer can be a 25% equity owner or a 25% voting rights owner. And so you could have a situation in which the Jones Company has a restrictive covenant agreement with employee Smith. The Jones Company decides not to do anything when employee Smith violates those restrictions, but a 25% owner of the Jones Company is offended enough by Mr. Smith's conduct that 25% owner decides to separately bring an action to enforce those restrictions. Now, I will tell you that I've not seen an appellate case in which that's actually been done, but that is a change in Georgia law that broadens the scope of who can actually enforce these kinds of restrictions. And you can probably imagine situations where that might give a minority owner a fair amount of power to get a company to do something that the company may not be interested in doing. So when you get to covenants not to solicit customers, those are governed by OCGA 13853B, and I do have statutory cites on most of these slides. A covenant not to solicit customers is a covenant where an employee or a franchisee or one of those other categories of folks that are listed as, quote, employees in the statute one of those individuals agrees not to go out and solicit business from the employer's customers. And that kind of a restriction can last up to 2 years without any need for the employer to justify the length of time. If there's a particular reason why the employer needs a longer period of time, then there may be ways to convince a court that a longer period of time is reasonable, but the statute specifically contemplates that 2 years is reasonable. If the person is not an actual W-2 employee, but is perhaps a franchisee or a licensee or one of these other categories of people that are lumped into the broad definition of employee under the statute, then in some instances, a 3-year duration may be considered reasonable. If this is a non-solicitation of customers connected with a sale of a business, then an even longer term, 5 years, can be considered reasonable. So what can be restricted? It is sufficient to simply say in the covenant that the employee will refrain from soliciting the employer's customers, including actively seeking prospective customers with whom the employee had material contact during the employment, if that solicitation is for the purpose of providing products or services that are competitive with those provided by the business. And it's sufficient now under Georgia law to make a good faith estimate at the time that the agreement is signed as to who those customers are going to be and what kind of products or services are expected to be competitive with the business. And that is a change in Georgia law from the previous scenario, because previously the estimate had to actually be based not just on what was expected at the time of signing, but also what was reality when the employment ended. And so now, even if the estimate is wildly off base by the time the employee leaves the employment, if it was considered a good faith estimate of the scope of the work to be done that should be restrained when the agreement was signed, that is at least in theory enforceable. And the concept is that if it's considered overbroad by the time the employment ends, just leave it up to the trial courts to sort it all out and appropriately narrow the restriction so that it's only applied to the scope of the employee's actual work as of the time the employment ends. If that sounds confusing, that's because it is. There's a reliance in this statute on employers being able to guess at the time the employment agreement is signed as to what they're going to need protection from when the employment ends, and also a reliance on the trial courts, our superior court judges who have very heavy caseloads, sorting out the facts and deciding what an appropriate restriction actually is based on what the employee was doing at the time of leaving the employment. I don't think that that's turned out to be a very reasonable reliance, because the superior court judges do not appear to be at all interested in modifying these kinds of restrictions to render them properly enforceable if they were drafted in an overbroad fashion to begin with. In terms of what the non-solicitation agreement must specify as to customer or geographic territory, it is not necessary to specify a geographic territory in which the non-solicitation is going to apply. Instead, it is sufficient to simply say that the restriction on solicitation of customers will apply to customers with whom the employee had material contact, or even name specific customers without actually getting into any particular geographic territory. So I've talked about material contact. And that is a concept that is critical to an understanding of these kinds of covenants. So material contact is, in broad terms, contact with a customer for the purpose of furthering the company's business. And so material contact would not be saying hello to your neighbor who happens to also be a customer of your employer. It would actually be talking with somebody about matters, about sales or other matters that are actually for the purpose of furthering the company's business. The statute actually has a very long list of what can qualify as material contact. So this could be just dealing with the customer on behalf of the employer. It could be supervising somebody else's interaction with the customer on behalf of the employer, such as a sales supervisor. It could be a situation where the employee maybe doesn't interact with the customer, but has gained confidential information about the customer through their work. Or it could be somebody that it could be material contact could be interaction with an entity in a sales capacity, or where the employee receives commissions or some other kind of compensation that is tied to interaction with that customer. And the reach back period is 2 years. And so if you've got an employee that works in sales and supervised somebody selling to customer A 2 years ago, and hasn't supervised any further sales to that customer A in 2 years, in theory, the restriction on solicitation could even apply to solicitation of that customer A, because the interaction was within the last 2 years. Solicitation has to be something more specific than just a mass mailing or an advertisement. So there has to be some sort of targeted effort to obtain business from the entity as to which solicitation is barred. So that could be calling up, meeting with the customer to try to solicit business. That could be sending a personalized letter to that customer, trying to solicit business. It has to be something targeted to that customer, not just a mass mailing or a radio ad or something like that. If the customer is unsolicited, in other words, if the customer comes to the employee without the employee having done anything active to obtain that business, the statute appears to permit a restriction on that type of acceptance of unsolicited business. And that is a change from the prior law. But there is no appellate case that I've been able to find where that is specifically addressed. And certainly it's hard to imagine why an employee or former employee who is really doing nothing to solicit business should be barred from simply accepting business from somebody who seeks him or her out. Unresolved question: what will trial courts actually do to modify overbroad covenants? So far, the answer seems to be that the trial courts are unwilling to do that. As a reminder for those who may or may not have dealt with the prior law, prior to 2011, blue penciling or modifying of restrictive covenants was completely disallowed in Georgia. A restriction had to be enforceable as written, or else it would be struck down altogether. The statute affirmatively authorizes courts to modify restrictions and so as to narrow them and make them enforceable, and then to enforce those narrowed restrictions. What I found, though, is that the few appellate cases that have looked at this issue have affirmed exercises of discretion by trial courts to decline to modify a restriction. And so the trial courts have instead been permitted to simply say the restriction that would be needed, the revision that would be needed to enforce this restriction is more than I believe as a trial court is a reasonable thing for me to do. I exercise my discretion to simply conclude that the restriction as drafted is overbroad and that it would be unreasonable for me to try to modify it, so I'm not going to enforce the restriction. One of the reasons stated for the change in the law in 2011 was that it is sometimes difficult to draft an enforceable restriction, and a lot of supporters for the change envisioned that allowing modification of overbroad restrictions would result in more of these restrictions being enforced by the courts and would give employers a little bit more ability to enforce restrictions on former employees who had left and were doing things that caused economic harm to the employer. What we're seeing is that the trial courts are just not interested in spending time trying to determine what would be an appropriate narrow restriction, and instead are just, for the most part, saying we're not going to do that. The restriction is going to have to stand or fall based on how it was drafted. And so for those folks that thought that maybe they'd be able to enforce restrictions that might not have been drafted with sufficient care to begin with, I think that is that's not the way it's played out. Now, there are fewer of these kinds of cases reaching the courts so far, and that is probably a result of both employers and employees being uncertain what a trial court would do in interpreting and enforcing a restriction. And so there has probably been more emphasis among practitioners on trying to negotiate resolutions rather than going down to court to argue over a restraining order. But I think as more time passes, it becomes more apparent that that employees can fairly safely assume that most trial courts are not going to be revising and narrowing these restrictions. So in that respect, the statutory authority for trial courts to do that has not really been something that the courts have taken up. How far back can the company reach? I think I talked about this already. The statute indicates that a restriction on solicitation can reach back to relationships that the employee had over the last 2 years of employment. There is no case that has interpreted that. So I can't tell you that there's a case that blesses that statutory interpretation, but that seems to be a reasonable interpretation of the statute. And my guess is that a court would enforce that. Covenants not to solicit coworkers, not to poach. So these are restrictions on an employee leaving an employment and taking his or her team with him or her, or even just taking a couple of people with him or her. And right now, it is not entirely clear which workers are off limits, but it is safe to assume that if you are if you're looking at an employee taking with him or her employees that he or she worked directly with, then a no poach agreement addressing those kinds of employees is likely to be enforced. If it is a restriction that reaches back to employees with whom this employee worked directly over the last year or two, that's likely to be enforced. If it is a restriction on poaching any employee of the company, and it's a company that has 1,000 employees, then that kind of restriction is likely to be considered overbroad. And then the employer would be in the position of, once again, trying to convince a superior court judge to just narrow it to enforce that restriction as to just the immediate group of people with whom the employee worked. And as I said a few minutes ago, I don't think that the superior court judges are all that receptive to narrowing restrictions in order to enforce them. How long can a no poach agreement be in effect? 2 years is safe. It's the reasonableness is going to depend on the specific facts, but for the most part, a 2-year duration is likely to be a safe rule of thumb. The third covenant to talk about is non-disclosure covenants. Now, a non-disclosure covenant is different than trade secrets protection. Trade secrets are governed by statute, OCGA 10.1.761.4. And so long as there is an effort to protect information that truly satisfies the definition of a trade secret, then it doesn't matter whether the employee has actually signed a written agreement saying that the employee will protect trade secrets. That's a function of statute, and that in trade secret protection is going to be based on whether the information is in fact a trade secret and whether the information is the subject of reasonable efforts by the employer to protect it. Confidential information is kind of everything else that might be important to the company. And that is a creature now of contract, but also of statute because of the language of OCGA 13.8.51.3. So confidential information is considered by statute now to be data and information relating to the business of the employer, whether it's a trade secret or not, that it was disclosed to the employee or that the employee became aware of as a result of the relationship with the employer, that has value to the employer, is not known generally to competitors, and can include trade secrets, methods of operation, names of customers, price lists, financial information, projections, route books, personnel data, similar information, some of which may be a trade secret. And any such information can be subject to protection under a non-disclosure agreement. And under prior law, the duration of the non-disclosure agreement had to be reasonable. There had to be a specified duration, and it had to be a reasonable duration. Now, under the change to the law, the duration of a non-disclosure agreement can be forever as long as the need exists. So depending on what the information is, it potentially can be protected forever. Or if it's information that goes stale very quickly, then that non-disclosure agreement is only going to protect for as long as the information is not stale. In terms of how to craft a non-disclosure agreement that encompasses all these different types of information, some of which may go stale quickly, some of which may need protection forever, don't just rely on the language in the statute. Actually sit down with your client and figure out with your client what kind of information needs to be protected. And describe that information with enough particularity in the non-disclosure agreement so that folks can figure out what it is that they've got to treat as confidential. To the extent that you are simply telling employees, keep all of the company information confidential, that's probably not enough detail for the employees to really understand what their obligations are. To make sure that employees have been told what is considered confidential, and so that they can then be expected reasonably to take the necessary steps to protect that information from their use or improper disclosure. Assuming that the agreement is sufficiently detailed so that it's clear what is intended to be protected by a non-disclosure agreement, then the courts can be expected to enforce the non-disclosure agreement so long as the information is not stale. And there probably is going to be a need to demonstrate to the court not just what is covered by the agreement, but also why it is still important and how long that protection needs to be in place because of the nature of the information. The final piece of the puzzle is covenants not to compete. And prior to the change in the law, it had become so difficult under Georgia law to draft a post-employment covenant not to compete that a lot of attorneys, including myself, just simply stopped drafting them because they were unlikely to be enforced and might taint the other restrictions in the agreement. The statute specifically authorizes covenants not to compete during employment as well as covenants not to compete post-employment. A covenant not to compete during employment has to specify a reasonable scope, what kind of competition is barred, a reasonable duration, which could be simply the covenant is in place as long as the employee is an employee. And then it has to specify a reasonable geographic territory based on the company's needs. A covenant not to compete post-employment can only cover certain specific types of employees. There have been a number of cases over the years in which employers got a little bit greedy when it came to restricted covenants and even required people like, baristas and construction workers and various other people to sign restrictive covenants when clearly based on their actual job duties, there was really no special relationship or knowledge to protect. And so one of the things that the statute did was narrow who can actually be bound by a post-employment not to compete. So if you want to cover somebody with a post-employment not to compete, they have to be either a key employee, a professional, a member of management, sales or sales supervision. So a key employee would typically be just what you can imagine, somebody who has an integral role in the business. A professional would typically be, for example, a doctor. By the way, lawyers cannot ethically be bound by non-competes. There's a bar rule on that. So don't need to worry about that. But other types of professionals, particularly doctors, are often bound by these kinds of restrictions. Management, if the person is the manager, is a high-ranking executive with the company or is a division manager, and basically satisfies the executive exemption from the wage and hour laws, for those who have maybe looked at that exemption. If you satisfy that exemption, you're probably management. And then sales, if you are selling directly to customers, or if you are supervising somebody else's sales efforts, then absolutely you can be covered by a post-employment not to compete. And frankly, that's probably the most important area where these covenants need to be in place. Very importantly, unlike prior law, nobody else can be covered. Nobody else can be restrained by a post-employment non-compete. So if you're not a key employee, not a professional, not management, and not sales or sales supervision, you cannot be bound by a post-employment not to compete. Now, what is allowed in terms of scope? The restriction can be simply a restriction on engaging in the same type of work conducted by the employer, or authorized or offered or provided by the employer within 2 years prior to termination. The restriction does not have to have any more detail than that. The duration, if the duration post-employment is 2 years or less, it's considered to be reasonable. If you're dealing with somebody like a distributor rather than a W-2 employee, then 3 years or less is considered reasonable. Now, the territory can simply say that the restricted territory, geographic territory, is where the employee is working at the time of termination, or if the total size of the employer's territory is a reasonably small size, then the territory for the non-compete can simply be where the employer has its business. Alternatively, customers can be specified by name. The point is that the restriction has to describe a territory that can be knowable at the time of termination. Prior law was that the restricted territory had to be knowable at the time of signing. Now it has to be knowable at the time of termination. And so if the restriction simply says that it covers the territory where the employee works as of the date of termination, that's sufficient. A lot of unresolved questions under non-competes, even after 11 years. As I mentioned earlier, there is this issue of whether trial courts are really going to be receptive to narrowing a non-compete that is drafted in an overbroad fashion. So far, the courts have not been receptive, even though the statute allows them to do that type of narrowing. Instead, so far, the courts have exercised their discretion to refuse to enforce an overbroad restriction and not to try to rewrite it. The statute indicates that it is permissible to specify a non-compete that is tied to specific customers rather than a geographic territory. It's not clear from the little bit of case law that does exist whether that's too vague of a wording. And so it strikes me as a little bit risky to tie a non-compete to customers rather than a geographic territory. So I would instead recommend using a narrow geographic territory. So let's assume that there is an enforceable set of one or more restrictive covenants, that the employee has violated those covenants after leaving the employer. And so now it becomes a matter of what to do about it. The first thing is that the employer has to plead and prove that there is a legitimate business interest. So in other words, it's not enough to just say, I have this covenant that the employee signed, so court, please enforce it. The employer also has to plead and prove that there is some business reason why the covenant needs to be enforced. That could be for the purpose of protecting trade secrets or confidential information. It could be for the purpose of protecting relationships with existing and prospective customers, clients, patients, and even vendors. So restrictions on relationships, even with vendors, can be enforced. Or a legitimate business interest could simply be protecting goodwill. How does one enforce? I talked about TROs before. The playbook basically is that if the harm is serious enough to do something about it and you find out about it pretty quickly, then the best first step is to, well, send a demand letter, a cease and desist letter, and then assuming that's ignored, try to get into court to get a temporary restraining order entered, followed by an evidentiary hearing and a permanent injunction. Of course, money damages are also available to the extent that harm can be demonstrated. There is also the tool of asserting a tortious interference claim against the new employer. Now, that's a little bit risky. You've got to make sure that you have a firm case against the employee before you start blaming the new employer for essentially assisting the employee with violating restrictions by going to work for the new employer. The reason I say that that can be risky is that the new employer's first step may be to terminate the employee so as to avoid being dragged into litigation between the employee and the initial employer. And if that happens, then the employee could certainly turn around and assert a counterclaim for tortious interference between the employee and the new employer. So it's important to be very thoughtful before asserting a tortious interference claim against the new employer because of the risk of a counterclaim back. And of course, ultimately, the best step, if you can do it, is to find a way to negotiate new terms that everybody can live with. And so sometimes the TRO and the threat of the injunction and the money damages, et cetera, are really just the way to get to new terms that everybody can live with. How does Georgia compare to other states? Georgia has gone the opposite direction of most of the other states. California famously does not enforce non-competes. It enforces protections for trade secrets. It enforces non-disclosures. But non-competes are considered in restraint of trade. They are considered, frankly, counterproductive and just not enforced. A lot of other states are trending in that direction. There is also a move afoot at the federal level to change federal law and also adopt a ban on various types of restrictive covenants, particularly with respect to certain types of employees. So we're trending the other direction, which seems to happen a lot with Georgia in certain cases. But bottom line is that although this law has been around for 11 years and seems to be an outlier compared to other states, there's also an awful lot that we don't know about what the courts are ultimately going to do to enforce these kinds of restrictions. So far, there's not been a lot of enforcement that's different than what was done under the prior law, but a lot of unanswered questions. So speaking of unanswered questions, if people have questions for me, I am happy to answer them. And I do see that there may be some questions. See, there was a comment, my friend Ray Stanford, seems to be a prevailing practice of using an unbounded indefinite duration for a non-disclosure covenant. Ray, that's correct. I think that is what a lot of employers are doing. The question that is unclear at this point is, even though the statute permits that, are there going to be situations where the courts say that the restriction is unreasonable because it doesn't have a duration specified? And so it may be risky to go with no duration and hope that a court agrees that that is reasonable. Question from Martha, can I explain why attorneys can't ethically be bound by covenant not to compete? Well, there's an ethics rule that says that, and so whether we think it's a good rule or a bad rule, that is the ethics rule. I think that the reason for that is that clients should be permitted to engage the counsel of their choice, and an attorney should not be prohibited from providing client services to a client that wants to engage that attorney. And that's what would happen if attorneys were required to sign non-competes. There actually was an effort probably about 15 years ago by one or more law firms here in town to have attorneys sign non-competes, and it quickly, there was some quick pushback on that. So I think that's the ethics analysis. Does the bar rule that prevents non-competes for lawyers apply also to in-house counsel? I believe it does. I'd have to look at the actual rule to be certain, but I believe that it does. What about in relation to the sale of a business, or if severance is being paid, doesn't that make courts more likely to enforce? So we're talking about two different things. The sale of a business, the restriction can be of a longer period of time. It can be 5 years. And that is because conceptually, when you're selling a business, you have greater negotiating power than you do if you're an employee, and presumably being compensated for the sale of the business. And so it is fair to have a longer period of time. In terms of whether it matters if a severance is being paid, certainly if a severance is being paid, it is more difficult for an employee to argue that he or she is unable to earn a living, or that there are other reasons why it would be unfair to enforce a restriction against that person. So I think that that is information that the courts take into consideration when they're deciding whether a restriction is reasonable. I think those are all the questions. So. Are there other questions from anybody?
Mari, I've got one. How do you see the law that you've just gone through impacting non-disclosure agreements between two businesses, if at all?
Well, so when I talked about the definition of employer and employee, that actually, let me go back to that. Let me cycle up and find that definition. It's a very broad definition. So an employee can include a licensee or a broker, for example. And so what that tells me is that the kind of non-disclosure agreement that you're talking about is probably covered by this act. And so if the information is within the definition of confidential information that I went through a few minutes ago, then it would be subject to the protections under this act. And so going back to this definition at 13.851.3. And so the parties to that agreement would be bound by the scope of this act, and the party that violated would be subject to enforcement. So I think that this is what would control.
Thank you. I see a question about the slides. I think Lane was sending out the slides right after the program began. So hopefully when you get off and look at your inbox, you will have those. If we don't have any other questions, I want to remind people that the annual Privacy and Technology Law, what used to be the Institute, now called the Forum, will be on March 29th and 30th this year. It will be done all remotely due to the recent surge in COVID cases. We had hoped to do it live or have a mixed forum this year, but it will be remote, so be on the lookout for that. Thank you so much, Mari, and that concludes today's program. Thank you.
Thank you.
Thank you for joining today's meeting. This does conclude the program. Have a great day.